Okay, so I think
All right.
we
We're
should be
live
about
on
to go live
YouTube.
here.
Yeah, we are live. That's what it tells me.
Okay. Yeah,
All right.
I'm watching it online and it's still kind of circling, but I think we are okay to get started here.
Yeah, it indicates to me we're live on YouTube.
Yeah. So if everybody can mute and we'll have.
Mute.
So I can call the meeting to order.
We're
good.
You have to mute.
You have to mute.
Okay, go ahead, Chuck.
Oh, no.
All right, we'll call the meeting to order.
Oh, I can't hear them.
Christine sent
That's
you
okay.
all your last meeting's minutes. Any problems with those minutes? If there's no problems, can I get a motion to accept them in those minutes as read?
I saw Sean and Dan.
All in favor?
Great.
Any pecuniary interest on the cases before us this evening from any member? Dave? Sean? Barry? Dan? All right. The first application is minor variance file 20-A08. May we hear it, Christine?
Yes. The subject application concerns lands municipally known as 11 Doe Lane, formerly Sunnydale, and legally described as Plan M521, Lot 1. The purpose of the application is to request the approval of the Committee of Adjustment for relief from the following. Section 2.6.1.1, no accessory building shall be located in the required front or exterior side yard. And section 2.6.1.2 to allow a detached accessory building to be located further than the exterior side wall of the main dwelling. The detached accessory building is proposed to be set back 18 meters, 60 feet from the exterior side property line being Fawn Crescent. The effect of the application is to allow for the construction of a detached garage on the subject lands. There were no comments received. And I have a recommendation from the Planning Department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves minor variance 20-A08 pertaining to lands located at 11 Doe Lane, Clearview, and legally described as Plan M521, Lot 1, on the basis that it meets the 4 tests in accordance with the Planning Act. And that's all I have.
So I do not see a representative for this application.
Actually, Chuck, James Hoover has joined the meeting. James, if you're able to unmute your microphone.
Surely.
James, can you hear us? Okay. Hi, James.
Yeah, there we go.
Okay, great.
James, do you have any comments that are not currently on your application that would assist us in making a decision on this subject?
No, I don't.
All right, then. Any comments from the members to James? Barry?
No,
Dan?
No, I have no comments or concerns to the application.
Sean?
No, pretty straightforward. Thank you.
Dave?
I have no comments, questions, or concerns with the application.
All right. Do we have a motion to accept this application?
I will
Dave?
make that motion.
All in favor? Accepted. James, there's a 20-day appeal period before you can put a shovel in the ground. And you'll need to get your permit after that appeal period from Christine.
That's great. I appreciate all the work.
No problem. You have a great night, sir.
You too. Thank you.
Our next file is minor variance 20-A09. Would you like to read it to us, Christine?
Yes. The subject application concerns lands municipally known as 72 Caroline Street West, Creemore, and legally described as Plan 138, Part Block A, and Reference Plan 19688, Part 1. The purpose of the application is to request the approval of the Committee of Adjustment for relief from the residential estate zone interior side yard setback requirement of 6 meters to 3.5 meters. The effect of the application is to allow for the construction of an attached garage to an existing dwelling on the subject lands. Comments were received from the Nottawasaga Valley Conservation Authority, from Clive Vandenberg and Laura Walton, all having no concern or objection to the application. And I have a recommendation from the Planning Department that the Committee of Adjustment of the Township of Clearview hereby approve minor variance 20-A09 pertaining to lands at 72 Caroline Street West, Creemore, and legally described as Plan 138, Part Block A, and Reference Plan 19688, Part 1, on the basis that it meets the 4 tests in accordance with the Planning Act and with the following condition: that the attached garage can be built 3.5 meters from the interior side yard on the western property line. And that's all I have.
John and Deidre, do you have anything to add that is not currently on the application to assist us in making the decision on this request?
No, we do not.
No.
All right then. Any questions from the members to the representative, starting with Barry?
Yes, I just want to be clear that you understand this condition, that it says the garage can be built 3.5 meters from the interior side yard. You're aware of that condition? You understand that condition?
Yes, I do.
I'm good, thank you.
Thank you.
Any comments or questions, Dan?
I have no concerns with this one either. It looks pretty straightforward and looks like a good addition to the house.
Sean, any questions or comments?
No, Mr. Chairman.
Dave?
I have no concerns with this application either. It looks fine.
Do we have a motion to accept this application? Sean? All in favor? Passes.
Thank
So
you.
John and Deirdre, you have a 20-day appeal period before you can put a shovel into the ground and get your permit before you do.
We will.
Thank you for your time.
Thank you very much.
Appreciate it.
Have a great
Thanks,
summer.
folks. Enjoy your evening.
Thank you.
You too.
Our last file before us this evening, consent file 20-B02. Christine?
The subject application concerns lands municipally known as 2634 Concession 10 North, formerly Nottawasaga, and legally described as Concession 11 and 12, Part Lot 38, and Reference Plan 51R 32335, Parts 4 to 7, Reference Plan 51R 32325, Parts 1, 4, and 5. The purpose and effect of the application is to sever a portion of lands from 2634 Concession 10 North and add the severed portion to the adjacent lands located at 795455 Collingwood Clearview Town Line. The proposed severed parcel is 80 meters of frontage, overall 2.25 hectares vacant land. The retained lot, approximately 375 meters of frontage, overall 92 hectares with golf course, clubhouse, and storage buildings. Comments were received from Hydro One, David Close, and Steve Cohen, having no objection to the application. And I have a recommendation from the Planning Department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves consent 20-B02 pertaining to lands at 2634 Concession 10 North, Nottawasaga, and 795455 Collingwood Clearview Town Line, subject to the following conditions. One, that the applicant meet all the requirements, financial and otherwise, of the municipality, including payment of the fee of $150 for each certificate of consent to be issued. Two, that the applicant provides a description of the land which may be registered under the requirements of the Registry Act or Land Titles Act as applicable. Three, that any mortgage on the property be discharged from any lands being severed, and for any lands to be added to a lot with a mortgage. That mortgage shall be extended onto the additional land, and that the solicitor provide an undertaking in writing that this condition will be fulfilled. Four, that the applicant successfully apply to the municipality to amend the township zoning bylaw for the severed parcel from a commercial recreation land zone to rural zone to reflect the zoning of the land that is being added to. Five, that the property to be severed is conveyed into the same name as the owner abutting land to the southwest, being assessed as roll number 4329-010-012-09202, being 795455 Collingwood Clearview Town Line, and that the solicitor provide an undertaking in writing that this condition will be fulfilled, as well as putting the PIN number from the receiving lands on the severed lands. And six, that a 1 foot square be taken from the lands receiving the severed parcel known as 795455 Collingwood Clearview Town Line, Clearview, if required, to allow the severed lands to be merged. If required, the 1 foot square can be conveyed to the Township of Clearview and added to the road allowance. The Township of Clearview will require correspondence from the applicant's solicitor that they have either done a title search and determined that the 1 foot square is not required, or that they have undertaken the process to obtain the 1 foot square as required to merge the two properties. And that's all I have.
Thank you, Christine. Andrew, do you have any comments that are currently not on the application to assist us in making a decision tonight?
No.
Why, thank you for your help. Any comments from the members of the committee, starting with Barry?
Yes, welcome, Andrew. The only question that I have is there's a standard number of conditions here, and I want to be sure that you and your client understand those conditions.
Yes, we're aware of all the conditions. I've reviewed them with both my clients. We're well aware of the 1 foot square and whether it is required. Vic Vandergust will deal with that. Just to be clear, we've already gone through the zoning bylaw amendment process, as you're aware, Deputy Mayor. So that condition number 4 has already been cleared. And the other ones are standard. We've already got Martin Nicely working on the survey of the property. So yes.
Great, thank you.
Any comments or questions, Dan?
No, I don't think I have any concerns with it. It looks like it's been laid out pretty well. So yeah, we're good.
Any questions or comments, Sean?
Yes, through you to Andrew. Are you aware of the previous history of this property with respect to the proposed development and the NEC application and hearing and so on?
Yes, Member Davidson, I'm well aware of it. I did some of the original mapping when my mentor David Slade went through the process for an NEC amendment, and that's one of the reasons I agreed to take on this file, was because, as you're aware, that was a more aggressive approach with 5 lots and then 3 lots. And you can see by this application, we're actually not creating any new lots. So just to reiterate, very familiar with it. And I've spoken to Judy Rhodes Monk a number of times with regard to it. And this is, I would say, the compromise we've come up with between Mr. McWilliam and Mr. Valentine. It seems to work for all parties.
So if a supplemental, if I may, so are they planning any type of redevelopment of this parcel once it is joined with the existing residential property?
No.
Okay, thank you.
Any comments, Dave, or questions?
Yeah, probably just a couple of minor things, a little bit of housekeeping. I'm curious, Andrew, who initiated the severance? Was it the receiver or Osler Brook?
I believe the way it worked was Mr. Valentine is a member at Osterbrook, and obviously Mr. McWilliam was out on the course. When COVID hit, so to speak, I think Mr. McWilliam was a little concerned about carrying the club through the summer. This application was submitted in the spring. The discussion the gentleman had on the course was that Jim and Bill had previously chatted about potentially doing this lot boundary adjustment. And it seemed like the time was right for both parties when we had the discussion in the spring. And so I would suggest to you that more or less it was a mutual, but Bill originally initiated it with Jim this spring.
Again, these are almost hypothetical or theoretical, so if you don't want to answer them, that's fair enough. Would it be fair to say that once the receiver gets the additional land from Osler Brook, that the size of the property at that point in time, while it is a single lot, could actually be developed into, and again, the zoning would have to change and so on and so forth, but it could actually become a commercial property. So what I'm thinking about is a single property, I don't know, small hotel or small motel. So the question is, would it be of size that something commercial could actually be developed on the receiver property 10 years down the road, 12 years down the road?
To the member, I'm not sure if Nick's still on, but I'm more than happy to answer this question. The response I give is that the property has recently gone to council to be rezoned. So it has been rezoned from commercial to rural, and therefore no commercial uses permitted on the property. So in terms of the theoretical, I would suggest to you that any commercial hotel would not be a permitted use on the property, and my client would have to go through an application to actually rezone back from a rural now to a commercial zone.
And sorry, just to add to what Andrew indicated, is as a part of the original proposal, this was our concern as well, that the land, if they remained as a rural commercial, recreational commercial zoning, that would be a possibility, but we did undergo a rezoning to take the lands to the rural, so it matches the receiving lands. So what we've focused on tonight is just the actual severance, or sorry, the lot addition application. If the applicant, if this applicant or say sells the property, another applicant comes forward, we have no control over that. But again, it would go through a separate process at that point in time, and it would be on its own merits. But the application before us right now is just the lot addition.
Understood, and I get that, and I can appreciate the comment that, you know, no additional properties are being made and so on and so forth. But we all know that we have no control over 10 or 12 years from now, and from my interpretation is that this could be with the additional property, this would be a size that something could happen with the proper zoning. But again, none of us have a crystal ball. That's my questions. Nothing too difficult. Just trying to wrap my heads around possibilities for the future. That's all. I also got a bit of information from member Davidson a little earlier, who had gone through this. I think Sean had said 7 years ago, which also alleviates some of the concerns that I may have had. So I thank him as well. That's it, Mr. Chairman.
All right, if there are no further questions, do we have a motion to accept this lot severance and consent file? Mr. Barry Burton, all in favor? Carried. Andrew, there is a 20-day appeal period. And then I would have to say that you and Nick would have to talk.
Thank you, Mr. Chair. Thank you, members. Thanks, Christine.
Welcome.
Have a great summer, Andrew.
You too. Take care. Bye now.
Is there any new business to bring forth, Christine?
I have none, unless any of the members have something they'd like to bring forward.
It does not look as though that is the case, Christine.
Okay.
Our next meeting is scheduled for?
September 9th, and we do have 4 applications for our September meeting.
Excellent. Do I have a motion to adjourn if no one has any comments to add to this evening's meeting? Yes, Mr. Barry, all in favor of adjournment? All hands up in the air. Excellent. It was a great meeting, gentlemen and ladies, and we will see you all in a month.
Thank you.